Session number 33 of the series on military law deals with the matter of human rights and the National Human Rights Commission. It is to be appreciated that just like on the lines of NHRC, each state is to have a state human rights commission, and number of states such bodies are already functioning. What are human rights? These are the basic rights and freedoms. As the word basic indicates, these are fundamental which form the yardstick or which forms the bedrock, and they belong to every person, and they belong to such category of human beings from birth until death. So this has to be appreciated that human rights are the rights which belong to all on this earth. They apply regardless of where a person originates, where does he belong, what he personally believes, how he chooses to live his life. Irrespective of all that, each person in the globe has these human rights. And these are based on shared values. What are these values? They pertain to like dignity, fairness, reason, equality, respect, and independence, freedom. These basic human rights can be categorized into, as far as the basic rights are concerned, right of life and liberty. The life is sacrosanct. A person is expected, he craves for, and he fights for his liberty. Freedom from slavery and torture, freedom of opinion and expression, right to work, and education. All these fall under the category, under the umbrella of human rights. In India, the Parliament enacted a law called the Protection of Human Rights Act 1933, beg your pardon, 1993. It defines human rights to mean the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the Constitution, which are embodied in the international covenants and enforceable by courts in India. Now, this is to be appreciated that these are those rights which have been guaranteed under our Constitution. They find their support and they follow international covenants, and these are enforceable by courts in India, and therefore anyone denied of these basic rights can approach and seek proper remedy from the competent courts. And this Act, Protection of Human Rights Act, shall be deemed to have come into force on 28th September 1993. It extends to whole of India, and it is now the law of the land. This Act provides for the constitution of National Human Rights Commission, NHRC, under Section 3, and this body, that's the commission, is to be headed by a former Chief Justice or the Judge of the Supreme Court. It has to have 4 members, and their eligibility and qualifications are indicated in the Act. We come to the functions of the commission. This is to be understood that commission has the authority to inquire suo motu, or it can do so when a petition is forwarded to it, maybe by a victim or any person on his behalf, or even on a direction or order of any court, where the complaint relates to violation of human rights or abatement for violation of human rights, negligence in the prevention of such violation by a public servant whose duty it was to ensure that that such rights are given untrampled, uninterrupted. The Commission can visit any jail or any other institution, for example, remand home, which is under the control of the state government, where people are detained or lodged for the purpose of either treatment or reformation or protection. It can study the living conditions of inmates in such institutions, and not only that, it can step beyond and make recommendations which it considers reasonable and necessary to the government. It can study other treaties and international instruments, human rights, concerning human rights, and after visiting such institutions, instruments, and documents, it can make suitable recommendations to the government for implementation of the human rights or the steps concerning them inserted there. The Commission is authorized and expected to undertake and promote research in the area of human rights. Then there is a clause pertaining to literacy and dissemination. It is to spread human rights literacy amongst diverse sections of the society, and it is expected to do that through publications, the use of media, seminars, or any other available means. It is to encourage efforts of NGOs and institutions working in the field of human rights, and it can undertake, it can take up, or it may be asked to perform such other functions as may be considered necessary for promotion of human rights in the country. NHRC has been invested with the requisite powers relating to inquiries about the violation of human rights. It has power to require any person to furnish information on such point or matters as may be useful or relevant to the subject matter of inquiry, and the provisions for this are contained in Section 18 of the Act. It is empowered to conduct investigation or have an investigation conducted for the purpose of any investigation relating to any inquiry. It can utilize the services of any officer, investigating agency of the central government or state government, of course with the concurrence of central government or the state government as the case may be, and for this Section 14 has been designed. The persons who are likely to be prejudicially affected by such an inquiry are to be afforded a right of opportunity of being heard, and if it where the Commission considers it necessary to inquire into the conduct of any person, or where it is of the opinion that reputation of any person is likely to be prejudicially affected, it shall give a right of hearing to such person, and this opportunity would be provided. This also is inserted in Section 16 of the Act. Other relevant section in this regard is Section 18 that deals with the steps during and after an inquiry. The Commission may take any of the following steps during or even after the completion of the inquiry where violation of human rights or negligence has been observed. It may then recommend for payment of compensation or damages by way of interim relief to the complainant or the victims or their family members. So it has a right to provide for compensation and damages. It can cause proceedings to be initiated for prosecution as it deems fit against the persons who are guilty, responsible for violation, or it can approach even Supreme Court or High Court seeking directions, orders, or writs that it deems necessary for that purpose. Section 19 is to be noted as it pertains to the relationship between armed forces and NHRC. If there is any complaint of violation of human rights by the armed forces personnel, then what shall the Commission do is there in this section 19, either on its own or where it has been moved by way of a petition, it can seek a report from the central government. I would repeat, the NHRC can seek a report from the central government with respect to any matter relating to violation of human rights, and after it gets the report, it has two options. Either it can decide not to proceed, obviously it would do so when it finds that the complaint was baseless, or it may make recommendations to that government in relation to matters pertaining to armed forces who would usually be subject to the military law. NHRC is expected or is to make recommendations to the central government. In turn, the central government is expected to inform NHRC within 3 months, or when the time is extended on its request, the Commission as to what action it has taken on that report. And thereafter, the Commission is expected to publish its report and the recommendation thereon. When they are published, then they get into the public domain, and it will also inform as to what action has been taken by the central government on the recommendations made by it, that is the NHRC. And a copy of the report which is published, this NHRC would supply it to the petitioner or his representative. Therefore, adequate transparency and effective measures for redressal of violations of human rights by armed forces personnel, there is a full law by itself under section 19 of the Protection of Human Rights Act. In the end, it is to be appreciated that the regulatory provisions which are there under section 19 relating to probes and investigations, they are there. However, efforts can always be made and should be made to achieve greater transparency so that the NHRC's report appear more credible and meaningful to the persons who are affected. Thank you.